पेटेंट नहीं ले सकते। सेम विद मैथमेटिकल एंड बिजनेस मेथड्स की अगर हम बात करें, सॉफ्टवेयर पर से की बात करें या एल्गोरिदम्स की बात करें, लिटरेरी, म्यूजिकल और आर्टिस्टिक वर्क की बात करें, या ए मियर स्कीम और मेथड ऑफ प्लेइंग गेम्स, यहाँ पे अगर आप फोर्थ पॉइंट देखेंगे, लिटरेरी और म्यूजिकल और आर्टिस्टिक वर्क, we cannot have patent, but it doesn't mean that you cannot have a intellectual property right creation, because intellectual property right, whatever the original ideas, whatever the original thoughts, when you fix in a medium, in any of the form, it gives a new shape of the intellectual property right creation. We will talk about how you can have a different intellectual property right on the literary, musical, software, and the different things like integrated circuit, presentation of information, that traditional knowledge which we were talking about, and the atomic energy. It is very easy to file the patent application. You may file while visiting the office. We are having presently 4 offices, Mumbai, Chennai, Kolkata, or New Delhi. You may file your application through IP India online GOV portal. So, which form you will have to file? There is a form 1, which are having application fee. You will have to pay. There is a form 2, which comprises a different detail of inventions, detail of foreign filing of similar invention fee, not required, declaration as to inventorship fees, not required, form 18. So this is the fees you will have to pay if you are natural person or startup or MSME or small entity or educational institutions. There is a 1600 fees. Other than that, if we talk about the companies, LLPs, then you will have to pay 8,000 fees. Form 18, 4,000 and 20,000. This is the basic portal which you will see when you will log in that page and fill the patent application file. So this is basically recent steps taken by the Government of India, Patent Amendment Rules 2021, where the fees is reduced more than 80%. Patent Amendment Rules 2021 has provided the facility for expedited application. So this is basically the steps we are following in our office, how your application go through. These are the basic levels of examine your patent application. Because of the shortage of time, and I'll have to cover more than 6 intellectual property right creations, then I'll share this slide to all of you. And if you are having some doubts regarding the patent filing or the copyright filing or the trademark filing, we can have a different presentation in different time. So these are the things which we are following in our Indian Patent Office. This is how we are doing the technical examination. Read and understand the invention, whatever you have filed. Search from our available data, publish that thing, check the novelty and inventive steps in your creative ideas or the patent application. So this is the basic timeline which we are having. Provisional to complete specification 12 months. Request, if you want to request for examination, 48 months. Reply to FER 6 months. Form 3 6 months. Withdrawal of application 15 months. Hearing submission 15 days. Or pre-grant of opposition before grant. This is the shape of certificate which we are issuing at the time of granting your patent. So another topic is a trademark. So what is the meaning of the trademark? If we see, there are two kind of trademark. One is a conventional trademark, another is a non-conventional trademark. Now if we see that India is growing very fast, and recently we have awarded a smell trademark. So now if we talk about the conventional trademark, which is in the form of word, name, symbol or devices, or with the combination of word, name, symbol and devices. If we talk about non-conventional trademark, which is smell trademark, 3D trademark, moving trademarks or sound trademarks. Why we need a trademark? Because it identify and distinguish the source of goods and services of one trader from other trader. So there are two terms. One is goods and another is services. If we see the NICE classification, which is acceded by India, that NICE classification, so that we can align with all the international scenario, which is headed by the World Intellectual Property Organization. So we are having a NICE classification, class 1 to class 34 for goods, class 35 to class 45 for services. Again, the trademark provide you a monopolistic right over a class of goods, oblique services, or to the different class of goods or different class of services. There is a new concept, not only a new concept, there is another concept which is called just wait. All the rights. Let it. Now the trademark is given for a 10 years initial terms, and after that you will have to file a renew your trademark application for another 10 years. So just wait. These are the basic examples of the trademark. One is the form of logo, which is designed in two colors, McDonald's. And if you will see the bottle of Coca-Cola, then you will find the different trademarks are included in this bottle. One is the shape of bottle, you can have a trademark on it. How the Coca-Cola is written on that bottle, and whatever the tagline is used by the Coca-Cola company. And if you see, there are different colors are used by the different trader just to have a monopolistic right or a right over color combination. If you see how the Google is written in different colors, that color intentionally put by the trader so that they can have not only have a right over the word Google, but also how stylized he has written and how the color they have used. Same with the Naukri.com. How stylized way they are having written on Naukri.com. Same with the tagline, Ye Dil Mange More. So in the line, if you'll see, there are many trademarks in a single line, a single tagline, Ye Dil Mange More. One, that bowl shape having a red and blue color and a white color in middle. And there is a certification mark. That certification mark is a Bureau of Indian Standard, BIS. Why the certification mark is given? To certify to the other traders as well कि उन्होंने उस क्वालिटी को उतना मेंटेन किया या नहीं किया. Same with the different stars which we are using. 3-star product, 4-star product or 5-star products, which shows the energy consuming devices. If you see कि मेरे को 3-star वाला रेफ्रिजरेटर चाहिए या 5-star वाला AC चाहिए. These stars are a kind of a certification mark taken by the trader from Intellectual Property Right Office to certify something. Now if we talk about Adidas, तो Adidas ने भी अगर आप देखेंगे तो it is a combination of 2 trademarks. One is a 3 stripes जो उसने लिया plus that word mark जो उसने Adidas को लिया और combine करके उसने एक trademark लिया Adidas. I mean, I want to tell you one thing, that you can have a different trademark in a composite mark as well. Now if you'll see the Columbia movies, जब हम कोई मूवी देखते हैं तो उसमें रोर करता हुआ अगर लायन आ रहा है या कोलंबिया की मूवी का एक ट्रेडमार्क आ रहा है, तो ये एक एग्जांपल है जो हमने ट्रेडमार्क लिया नॉन कन्वेंशनल ट्रेडमार्क की फॉर्म में. So why and what is the importance of your trademark? It allows a business entity to build a public goodwill and brand reputation. इसका एक लाइव एग्जांपल है अगर हम देखें इंडियन सिनेरियो में, जिसने नॉट ओनली इन इंडिया बट आउटसाइड इंडिया $1 million की इंडस्ट्री खड़ी करी विद इन नॉट मोर देन 7 to 8 years. कोई मुझे बताएगा कौन है वो? एक इंडियन कंपनी जिसने ऑल ओवर द वर्ल्ड अपनी गुडविल क्रिएट करी, ब्रांड वैल्यू क्रिएट करी. इंडियन ट्रेडर. Amazon is not from India. Anyone? कोई भी नहीं है बताने वाला? तुम बताओ भाई. अगर हम पतंजलि की बात करें तो पतंजलि ने विद इन 7 to 10 years अगर आप देखें तो नॉट ओनली इन इंडिया, आउटसाइड इंडिया उसने बहुत सारी ब्रांचेस को ओपन किया. तो दिस शोज हाउ फास्ट योर ट्रेडमार्क रिवॉल्व्स all over the world. It spreads all over their wings to all over the globe within 7 to 10 years. So it shows the identify the source and origin of the goods or services. Everyone knows now the Patanjali product comes from India. It assures the customers about the quality of goods or services. In order to protect a trademark infringement, it is necessary to get your trademark registered under the Trademark Act 1999, and there is a rule. Now we are having amendment rules 2021. In case of non-use, non-renewal, or no policing, trademark rights are lost. However, there is a term under the trademark enshrined which is called a passing off. Your passing off right will always be there, because ultimately in whatever the original ideas or creativity which you are having put in the mind of others never lost. So this is the basic subject matter of the trademark. Trademark may be in the form of trademark including service mark, trade names. There is a new term which is not only new term which is called collective marks, certification mark, taglines oblique slogans and the shape marks, जो कि आप यहाँ पे देख सकते हैं. टैगलाइंस भी है, शेप मार्क भी है, स्लोगन्स भी है, सर्टिफिकेशन मार्क भी है और कलेक्टिव मार्क भी है. कलेक्टिव मार्क हम कोका कोला की बोतल को देख सकते हैं. So what is the basic criteria for a good trademark? There must be a distinctiveness. Distinctiveness may be inherent distinctiveness and distinctiveness which is a acquired distinctiveness. If we talk about acquired distinctiveness, what is acquired distinctiveness and what is inherent distinctiveness? What is the difference between inherent and... Anyone know about the inherent distinctiveness and acquired distinctiveness? If we talk about hindumatrimony.com या travelEase.com, तो इन्होंने क्या किया, अपनी जो ट्रेडमार्क था उससे अपनी गुडविल को एक्वायर किया. Some trademark is having an inherent distinctiveness कि उनके अंदर already distinctiveness है. Like if you talk about the Reliance company, तो उनके पास एक inherent distinctiveness है, और एक ऐसा ट्रेडमार्क जिसने distinctiveness acquired करी through advertisement, एक ब्रांड इमेज बनाई through advertisement, social networking. Now there is another concept which is called a not deceptively similar. It is also called absolute ground, no, relative ground of refusals. Here we see whether particular mark is deceptively similar to others or not. If it is honestly adopted or a coined mark, then it gain a reputation, brand quality, brand image in a general public. It must not be similar to the pre-existing trademarks. Before adopting a new mark, it is advisable to have search, which is available in our IP India website. There you will have a AI chat box where you can access while put whatever the trademark you are searching for any class or goods or services. So how to indicate your trademark? One can write TM and one can write R. When you file your trademark application or not, you can use the word TM so that to aware to the general public that this is my mark and not to use it. And if you get a registration over your mark, then you can put that R symbol in a circle against your mark. But if you don't have any registration certificate, then you cannot use that R symbol because it is punishable under the Indian Trademark Act. So now there is another topic which is called a copyright. So copyright is called a bundle of rights. Why it is called a bundle of rights? Because your small creative things create many different horizon or many different types of rights. Like मैं एक नॉवल लिखता हूँ, या अगर आपने कभी जेके रॉलिंग्स का नॉवल पढ़ा होगा हैरी पॉटर, तो हैरी पॉटर जब उसने वो नॉवल लिखा था जेके रॉलिंग्स ने, तो उसने ये नहीं सोचा था कि इसके ऊपर एक इतनी बड़ी लार्ज स्केल पर मूवीज बनेंगी. या एक किसी ने एक कविता लिखी तो उसे नहीं मालूम था कि वो एक स्मॉल कविता एक मूवी में एक बहुत बड़े सॉन्ग का फॉर्म ले लेगी. या एक जो कलकत्ता की स्ट्रीट्स में एक गाना गाता था एक बंदा, कच्चा बादाम सॉन्ग, उसने कभी नहीं सोचा था कि एक स्मॉल सॉन्ग उसको इतनी बड़ी एक न्यू होरिजन और एक न्यू राइट क्रिएट कर देगा और वो फेमस हो जाएगा ऑल ओवर द वर्ल्ड. तो द स्मॉल क्रिएटिव थिंग्स gives a new shape and gives a new ideas and give a new rights in the form of intellectual property right creations. So this is the meaning of given by the intellectual property rights, that it gives you a bundle of right. And the another thing which is written, which is automatic right. Why it is called a automatic right? If we see there is a different treaties, especially if we talk about the Berne Convention, TRIPS and different convention headed by World Intellectual Property Organization, which says copyright is a bundle of right, one thing. Another thing is a automatic right. Means to say कि whatever the creativity, whatever the ideas you are having, and you are giving fixation on it. Fixation means when you communicate that idea to anyone in any form, on the very moment, whatever the right creates, it gives you the automatic rights in the form of copyright. जैसे कि अगर कुमार विश्वास कुछ भी गाता है या कुछ भी बोलता है, या अगर आप रेडियो एफएम पे या रेडियो जॉकी या कपिल शर्मा कुछ भी शो कर रहा है और जो वो बोल रहा है, ऑन द वेरी मोमेंट एक राइट क्रिएट होता है जो कि कॉपीराइट से गवर्न होता है, और ऑन द वेरी मोमेंट दैट राइट इज प्रोटेक्टेड अंडर द कॉपीराइट फॉर 50 years. तो वो 50 साल के लिए प्रोटेक्ट हो जाता है. नो नीड फॉर द एविडेंशियरी वैल्यू, नो नीड फॉर द रजिस्ट्रेशन. On the very moment, on the very thing, when you communicate your idea, the new right created. So whatever the right you are having, it gives you the another thing which is a exclusive right. Why it is say exclusive right? Exclusive right means अगर आप कुछ थॉट्स अपने शेयर कर रहे हो किसी भी फॉर्म में, तो आप जो भी उसके ऊपर होता है उसके ऊपर सिर्फ और सिर्फ आपका राइट होता है. यानी एक आपको छोटी सी एक कहानी सुनाता हूँ. 4 दोस्त गए जंगल में. एक्चुअली ये इंटरनेशनल केस भी है इसके ऊपर. और उन्होंने एक जब वो जंगल में गए तो एक का फोन उस जंगल में छूट गया. जब फोन जंगल में छूट गया, वो चारों दोस्त घर चले गए, तो उन्हें याद आया कि फोन तो जंगल में छूट गया. उन्होंने जंगल में जो फॉरेस्ट अथॉरिटी थी उनको बोला कि मेरा फोन वहां छूट गया है. 3 दिन बाद 3 दिन बाद क्या हुआ, उनको वो फोन मिला. उन्होंने उसको जिसका फोन था रिटर्न कर दिया. तो जिसको वो फोन मिला उसने देखा एक चिंपांजी ने, क्योंकि वो टच स्क्रीन था तो उसमें काफी सारी फोटो क्लिक हो गई. जब वो फोटो क्लिक हुई तो उसमें उसने जिसका फोन था उसने वो नेशनल ज्योग्राफिकल चैनल वालों को दे दी. तो नेशनल ज्योग्राफिकल चैनल वालों ने उसको कवर पेज पे अपने शो किया और उसके $1000 उसको दे दिया जिसने वो फोटो दी थी. तो जब फॉरेस्ट अथॉरिटी ने देखा कि ये तो चिंपांजी मेरा है, फोटो चिंपांजी की है, खाना चिंपांजी को हम खिलाते हैं, तो राइट उसका क्यों हुआ? क्योंकि कॉपीराइट बोलता है कि फोटोग्राफ के ऊपर राइट उसका होता है जिसने फोटो खींची होती है. तो whoever clicks the photo will get monopolistic right over the photo. So ये केस कोर्ट में गया और कोर्ट में जाने के बाद ये डिसाइड किया गया कि नेचुरल पर्सन को ही उसका राइट दिया जाएगा. आई मीन टू से, मैंने आपको इसलिए बोला ये केस, इसमें मैंने थोड़े से चेंजेस किए हैं आपको समझाने के लिए. तो इसमें इसलिए मैंने आपको बोला कि एक ऐसी चीज जिसकी की हम वैल्यू नहीं करते हैं जब हम फोटोज क्लिक करते हैं, हम उसकी वैल्यू तब करते हैं जब उसके अंदर मॉनेटरी एस्पेक्ट्स ऐड हो जाते हैं या फाइनेंशियल एस्पेक्ट्स ऐड होते हैं. सो इट गिव्स यू द एक्सक्लूसिव राइट ओवर योर क्रिएशन इन द फॉर्म ऑफ सर्कुलेटिंग योर राइट्स. अगर मैं कोई बुक लिख रहा हूं और उसे मैं सर्कुलेट करता हूं, मे बी इन द फॉर्म ऑफ बुक्स की शेप में, मूवीज की शेप में, सॉन्ग्स की शेप में, किसी ड्रामा की फॉर्म में, तो ये सारे राइट किसके हैं? जिसने उसको क्रिएट किया. सो दैट्स व्हाई इट इज कॉल्ड एक्सक्लूसिव राइट गिवन टू द क्रिएटर ऑफ ओरिजिनल वर्क ऑफ ऑथरशिप. इट अलाउज ओनर टू चूज वे इन विच कॉपीराइट वर्क आर मेड. यानी जिसने कॉपीराइट क्रिएट किया है ये उसके ऊपर डिपेंड करता है कि किस वे से वो उसको एक्सप्लॉइट करना चाहता है, यानी यूज करना चाहता है, पब्लिक को किस वे में वो बताना चाहता है. इट अलाउज ओनर टू प्रिवेंट अनऑथराइज्ड कॉपी और रिप्रोडक्शन ऑफ द कॉपीराइट. So basically there are three things when the copyright work is created or gives a value to your thoughts. One, there must be creativity. Another way is originality. Third is fixation. Fixation means to communicate your ideas to the general public. These are 6 subject matter of the copyright. One, in the literary work. Another, artistic work. Third, dramatic. Fourth, music. Fifth, sound recording. Sixth, cinematograph film. Who will be the first author or owner of the first owner of the copyright? If we talk about literary or dramatic work, the author will be the first owner of the copyright. If we talk about the music work, the music composer. If we talk about artistic work other than a photograph is artist. जो हमने अभी एग्जांपल देखा चिंपांजी वाला, तो वो है photograph, person who is taking the photograph. If we talk about cinematograph film or sound recording, the producer will be the first owner of the copyright. If it is literary, dramatic, musical or artistic work, which is computer generated, the person who causes the work to be done. ये जो कॉन्सेप्ट है moral rights का, you will not find or hardly find in any of the law regarding what is moral rights. So what is moral rights? Economic rights तो हमें मालूम है, लेकिन what is moral rights? चलो पहले इकोनॉमिक राइट देखते हैं. इकोनॉमिक राइट मतलब रिप्रोडक्शन राइट, यानी कि मैं अपने वर्क को कितनी बार भी रिप्रोड्यूस कर सकता हूँ. प्रिवेंटिंग अदर ऑफ मेकिंग कॉपीज ऑफ योर वर्क, राइट टू प्रोड्यूस वर्क इन अ मटेरियल फॉर्म. लाइक मैंने कोई बुक लिखी, उसकी कॉपीज को मैं एज मेनी कॉपीज एज आई वांट आई कैन डू दैट. डिस्ट्रीब्यूशन ऑफ द वर्क, कि मैं डिस्ट्रीब्यूशन चैनल को देखूंगा कि हाउ माय वर्क विल डिस्ट्रीब्यूट ईदर ऑनलाइन, ऑफलाइन और एनी अदर मोड. Right to create derivative work. Derivative means when I use a different translation, adaptation, compilation. Now there is a term adaptation. Adaptation means a simple or small corrections or some addition, deletion, arrangement or rearrangement of the facts, which will be done by the original author only. Cinema, suppose I have written some novel and now I want to convert that novel in a movie or sound recording. So that is also a derivative work. Right of communication to the public and right to public performance. Now what is the moral right? Right against distortion. यानी अगर मैंने अपनी कोई आर्ट वर्क अगर सेल भी कर दी है और उसका अमाउंट भी मैंने ले लिया है, even then that moral right will exist with me only. Yani whatever the intellectual property right you are having with the copyright, then you will have the right after selling your right. अगर आपने अपना जो right आपका ऑलरेडी है और आपने उसे बेच भी दिया है किसी को भी, even then उसको ये right नहीं है कि वो आपके वर्क को डिस्टॉर्ट कर दे. राइट ऑफ रिकॉग्निशन, अगर पिकासो की एक पेंटिंग है और वो पिकासो की पेंटिंग मैंने परचेज भी कर ली है, तब भी मुझे उसको वो राइट ऑफ रिकॉग्निशन देना होगा. These are the two rights given under the Copyright Act. So what is the term of protection given under the copyright? Life of author plus 60 years. But if we talk about international scenario, तो अगर आप बर्न कन्वेंशन को भी देखेंगे तो उसमें भी उन्होंने जो रिस्ट्रिक्शन लगाई है डिफरेंट कंट्रीज पे, तो उन्होंने बोला है लाइफ ऑफ ऑथर प्लस 50 इयर्स. लेकिन अगर हम इंडिया की बात करें तो इंडियन स्टैट्यूटरी लॉ जो इंडियन कॉपीराइट एक्ट का है, उसने बर्न कन्वेंशन में जो बोला है लाइफ प्लस 50 इयर्स, उससे भी ज्यादा 60 इयर्स तक 10 ईयर और ज्यादा एक्सीड किया है. Cinematograph, film or sound recording 60 years from the date of publication. Broadcasting reproduction right 25 years from the year following the year of broadcast. यानी अगर 2026 में एक मूवी आई है, धुरंधर मूवी अगर 2026 में आई है, तो वो 26 को छोड़ देंगे हम, 26 वाला ईयर काउंट नहीं होगा, उसके नेक्स्ट ईयर से 25 ईयर्स देखे जाएंगे. सेम विद द परफॉर्मेंस राइट. अगर शाहरुख खान कोई परफॉर्मेंस कर रहा है किसी स्टेज पे, तो शाहरुख खान जिस दिन परफॉर्मेंस कर रहा है उस ईयर को छोड़कर नेक्स्ट 50 ईयर्स या कपिल शर्मा का शो जो है अगर लाइव परफॉर्मेंस है, तो जिस दिन वो लाइव परफॉर्मेंस हुई उसके बाद वो वाला ईयर छोड़कर नेक्स्ट 50 ईयर्स. इट इज वेरी सिंपल प्रोसेस एंड वेरी सिंपल फीस. अगर हम बात करें लिटरेरी, ड्रामेटिक, आर्टिस्टिक, म्यूजिकल, सिर्फ 500 फीस है. आर्टिस्टिक 2000 है. अब आप अगर देखें तो पहले वाले वर्क में लिटरेरी, ड्रामेटिक, आर्टिस्टिक वर्क की 500, नीचे वाले में देखें तो भी आर्टिस्टिक है 2000, क्योंकि इफ योर आर्टिस्टिक वर्क is used to sell and purchase of your goods and services, then there is a fees 2000. means suppose मैंने एक लोगो डिजाइन किया and that logo is used to sell and purchase of the goods and services, जैसे कि रिलायंस का लेबल या फिर पतंजलि का लेबल या फिर डाबर का लेबल अगर मैंने डिजाइन किया है, so then I will have to pay 2000 rupees, one thing. Another thing, I'll have to take no objection certificate from trademark authority under section 45 ki kindly give the no objection certificate so that I can file a copyright application, and within 12 months you will have to file the application under the artistic category for a copyright registration. This is the basic step followed by the Indian Copyright Office. First, first the application is received by the Copyright Office. That formality check is done. Formality check means whether you have filed a right application, all the column you have duly filled. There is a waiting period. Waiting period is a 30 days period. 30 days means whatever the application you are filing, that goes for the publication for the third party objection. Once the 30 days period ends, then the examination is done, and if no discrepancy is found, then the application straightaway go for the registration. And if any discrepancy is found, then the discrepancy letter is issued and 30 days time is given and your reply is awaited. Once you file your reply, the application gets registered. Now there is a concept of design. So design is having some aesthetic value of the goods. These are some examples of the bottles of the different traders. So what are designs? It gives a protection over the 2D and 3D images or shapes or patterns. Protection is for the aesthetic aspects or the outward appearance of your product. Protection is not for a working principle, क्योंकि वर्किंग प्रिंसिपल कहाँ प्रोटेक्ट होता है? आपका पेटेंट में, जो प्रोसेस पेटेंट होती है. और इनिशियल पीरियड इज फॉर 10 years, which may be extended for 5 years. So what is the importance of the design? It helps the consumer to recognize any product, make a long-lasting effect of the consumer's mind. It add value to the product, help in gaining fair returns on the investments. In order to protect a design from an infringement, it is necessary to get it registered under the Design Act. अगर आप देखेंगे, अगर कॉपीराइट एक्ट की हम बात करते हैं तो हमने इंफ्रिंजमेंट की ऐसी कोई बात नहीं करी है, क्योंकि कॉपीराइट एक्ट gives you the automatic right. Here you will have to get a registration so that you can prove evidentiary value in the court that I am having that design, and then only the infringement action you can take or initiate against the infringer. Design registration prevent the duplication of the product. Design registration create USP, unique selling point, and product long lasting effect on it. These are some examples of designs. However, you can have a copyright on the that if we talk about the sarees, lehengas, etc. But if we talk about the basic difference between the copyright and design, under copyright you cannot have more than 50 industrial processing output. That's why generally the public goes for the design registration. So these are some design which are having some registration under the Design Act. ठीक है, किसी को डाउट डिजाइन में? Next, design of set of articles. Set means a number of articles of the same general character ordinarily sold together. So what is the basic criteria for obtaining a design registration? There must be novelty and originality. Novelty means a design can be considered for registration only if they are unique. Suppose if you have already shown to the general public a particular design, then you cannot have a design registration. A prior publication is not at all acceptable. Design should have not been disclosed to the public anywhere by publication in tangible form or by use or by in any other way prior to the filing date. Significance, distinguishable. Design should be significantly distinguishable from known design or combination of known design. Must not comprises or contain scandalous or obscene matter. Must not be contrary to the order or morality. Must not be prejudicial to the security of India. Should not include any sort of trademarks or copyright. If you are having registration under the copyright for any of your design, then you cannot go for the design registration. Same with the copyright. If you have applied any application for the design under the Design Act, then you cannot have a copyright over your design. The design cannot be registered. Sign, emblems or flags of any of the country, mere change in the size of any articles, structure of the building, layout design, integrated circuit, any principle or mode of construction of any article such as label, tokens, cartoon characters, etc. Books, calendar, certificate, jacket forms, workshop alteration of component of an assembly, part of any article which is not manufactured and sold separately. So there are two modes. You can file your design application straightaway directly. File the application to IPO Kolkata because design office is only in Kolkata, and you can file online application. This is the fees for the design application. For startup MSME, there is a 1,000 rupees fees. For a other than that, natural person company 4,000. Renewal जो है वो 10 after 10 years 5 years के लिए है, which is 2,000 and 8,000. This is the portal where from you can file your design application. what documents you needed to file a design application, an application form, fees, 2 copies of your design, a statement of novelty disclaimer in respect of trademark and copyright that you didn't have file application any sort of in trademark office. This is the basic steps followed under the design office: filing of your application, numbering, dating, examination, if any objection is found, then communicate, hearing is fixed, if your reply is not sufficient, and then advertise your design. Now there is a very good concept of the geographical indication for the upliftment of our village artisan and upliftment of India. That's why we have written invaluable treasure of incredible India. It is a sign used on product that have specifically geographical origin and possess quality or reputation that are due to that origin. If we talk about Rajasthan, then we will have some image of Kathputli. And if we go for the Darjeeling, then some image comes in our mind because of the Darjeeling tea. If we talk about saffron in Kashmir, so it not only promote that particular product, but it also promote the tourist attraction of that particular state. It gives the recognition, it advance the artisan and the development of the village, development of the villagers, and development of India as well. Same with the Makarana marble, Ratlami save, Kanjivaram silk. These are the examples of the GI products. So it states that a particular product belongs to a particular place. Since the quality depends on the geographical place of production, there is a link between the product and its original place of production. Granted primarily to an agricultural, natural, manufactured, handicraft product originating from a definite geographical territory. So why it is important for India? It gives a fair competition. It gives a good market recognition. It creates a premium price, rural development, which is very much important, protection of knowledge and community rights. There is a statutory provision which covered under the Geographical Indication of Goods Act 1999. Now, who can apply for registration of GI? Any association of person, producer of that particular region, organization, any authority established by law. There is an initial term 10 years as in trademarks. It is a perpetual right given, renewable at an indefinite period of time for 10 years for every renewal. Another concept is SICLD, Semiconductor Integrated Circuit Layout Design. What is SICLD? Which means a product having transistors, other circuits element inseparably formed on or inside a semiconductor or insulating material designed to perform an E-circuit function. Integrated part of every computer chip, VLSI chip, VSLIC chip. Layout design means layout of transistors and Other circuitry elements include LED bars connection, such element and expressed in manner in a SIC. These are some example design uses for SICLD. These are some features or silent points on SICLD, which is important IPR protection product, which is fast changing technology such as electronic gadget, computer, etc., etc. Criteria for SICLD: it must be original, distinctive, distinguishable from other layout design, not commercially exploited. For Office for SICLD registration, SICLD registry is the office where application of the layout design or the registration you can file. There is a statutory act or the provisions, SICLD Act 2000 and rules 2001. Term of registration is 10 years from the date of application of filing, whichever is earlier. Infringement of a registration, layout design or any falsification may attract a penal action. This is the following step we are having under SICLD: filing of application, numbering the application, examination, and if we found any objection, then we raise the objection letter, and after receiving your replies, first we issue the advertisement, or if it is not up to the mark, we give the hearing and refusal. This is the fees for SICLD registration: 5,000 for your application for registration. If you want to oppose any application, then you will have to give 500 rupees. And if you want to file a counter statement, again 500 rupees. Notice of intending the hearing 500, clerical error 300, etc. So thank you very much for bearing me 1.5 hours, I think. If any sort of question you are having in your mind, please, we can have 2 or 3 questions.
Thank you, sir. Thank you very much for your informative lecture on various aspects of intellectual property and other things. Sir, before going details, I'll just quickly take some questions. Some of the questions that I have already received, I'm just reading. I don't know whether can you see these questions?
It would be good, sir, if you can speak, and then I will
Okay,
answer.
no problem. No problem. No. So one person he's asking that only any innovative idea itself can give patent or practical applicable device design should be given or not?
As I told you that for any sort of original ideas you are having and you fix that idea in any sort of medium, so maybe we can have a registration when we communicate that idea, maybe in the any form, literary, dramatic, artistic, or any sort of medium, then you can have a copyright on it. But if we talk about the industrial applicability and novelty features and things, then you can have a patent application. You can file your patent application. But there must be some product or process patent only, not more than that. But even then, if you are having some idea and you are giving that shape to your ideas, then I must tell you that you should file a copyright application for that. And first you have a copyright on it. And after that, if you want some protection and you are having some device, you having some process, then you can go for a patent, no problem in that. Because ultimately, copyright is a big law where you can have a copyright on whatever the ideas you are having, and you give shape to your idea, communicate your idea, or you fix your ideas.
Okay.
So one more thing, an idea per se is not the intellectual property right creation unless you communicate that idea in any of the form. Idea per se is not registrable.
Okay, sir. Thank you, sir. Sir, another interesting question that the symbol R and TM, that what we are using. So what is the basic difference of between these two words?
Actually, when you use your R, when you get a registration certificate from the Government of India or the Trademark Authority, unless you cannot write the R symbol. But whether you have filed your application or not, you can use your TM against your trademark, so that one to other, please don't use that trademark because it belongs to me. So ultimately, it is a warning sign given to the other traders. Don't use your mark. Don't use my mark. That's why we use a TM symbol, or some traders is using a SM symbol. However, SM is nowhere defined. Even TM is nowhere defined as such in the Trademark Act. However, R symbol is there. You cannot use the R symbol. But now the trademark traders are using SM or TM. SM is a service mark and TM is a trademark.
Okay.
Thank you.
Thank you, sir. Sir, just one second. One more question that we have received: whether this trademark and patent applicable only in India or globally? If suppose I have patent which is applicable only in India or entire globe? Sir, can you hear me? So can you hear me?
Disconnect हो गया था.
Oh, I see. Sorry.
अभी मैंने मोबाइल किया है.
Okay, no issue. Sir, there is another question: whether this trademark and patent applicable only in India or globally? If suppose I have patent which is applicable only in India or entire globe?
एक्चुअली ट्रेडमार्क के अंदर अगर हम बात करें तो वी हैव अ कॉन्सेप्ट ऑफ द मैड्रिड. वी रिसेंटली एक्सीडेड टू द मैड्रिड प्रोटोकॉल, where you can file your international application through a single channel, in a single medium. Like if you want to file a French application, then you need not to go to France and file that particular application. You can sit in India and you can directly file the application in English language. So and with the Indian rupees. However, the fees is paid in the Swiss francs. लेकिन अगर हम बात करें इसकी कि ये इंटरनेशनली वैलिड होगा या नहीं, लेकिन बिकॉज अगर हम कॉपीराइट की बात करें तो वो तो देयर इज अ बर्न कन्वेंशन, तो हमारा ऑल ओवर द वर्ल्ड रहेगा. लेकिन ट्रेडमार्क और पेटेंट के लिए यू विल हैव टू फाइल अ एप्लीकेशन वेयर एवर यू वांट टू spread your wings. Suppose I like to use my trademark in US, then I will have to file an application in USPTO.
Yeah.
And if I like to use my trademark in UAE, then I will have to file an application in UAE. So there is some barriers. We can say the state barriers, country barriers.
Okay, sir. Thank you. And sir, another question is eco-friendly? Sorry.
कोई बात नहीं, take your time.
Sorry.
कोई बात.
How to work as patent agent? Another person is.
For the patent agent, you will have to clear an exam for the patent agent exam, which we are conducted every year. So for that, you will have to give an exam. Any other questions, sir?
Yes. Yes, another person is asking if someone truly originated new idea or concept, probably others or beyond territory could also develop such things previously, is there any credit or right based on territorial boundary, since logic could arise probably time along the varies, so not to worry about first come or first come. Anyway, so he's asking that is there any credit or
I get this
any,
question.
yeah.
No, it's okay. Just wait. I'm audible to you, sir?
Yes, now you're visible also.
चलो अच्छा है। तो सर ये क्वेश्चन मेरे समझ में आ गया है। वो ये पूछना चाह रहे हैं कि फर्स्ट कम फर्स्ट बेस है या नहीं है। अगर हम कॉपीराइट की बात करें तो व्हाटएवर द आइडियाज और original things you have created, that is not first come first base, but you will have to prove that this original idea belongs to you only. सपोज मैंने एक बुक लिखी और बुक लिख के मैंने उसको अपनी अलमीरा में रख दिया, ठीक है, मैंने उसे जनरल पब्लिक को बताया नहीं। उसके बाद मेरा एक फ्रेंड आया 10 इयर्स के बाद, उसने वो बुक उठाई और पढ़ी, उसे बहुत अच्छी लगी, उसने अपने नाम से पब्लिश करा दिया। सो अब इस केस के अंदर अगर हम देखें तो अब आई विल हैव टू प्रूव कि ये मेरा वर्क है, तो बर्डन ऑफ प्रूफ तो मेरे पर आया, क्योंकि अल्टीमेटली उसने जाके रजिस्ट्रेशन करा लिया और मेरी गलती ये थी कि मैंने कम्युनिकेट नहीं किया। सो कॉपीराइट की अगर हम बात करें तो वो बोलता है कि जैसे ही मैंने कम्युनिकेट किया, यानी फिक्सेशन इज इंपॉर्टेंट। अगर हम कॉपीराइट की, मैंने जो आपको स्लाइड भी दी, मैं आपको शेयर करूंगा, आप सबको कर दीजिएगा। तो जैसे ही मैं अपने ओरिजिनल आइडिया को फिक्स करूंगा, फिक्सेशन इज इंपॉर्टेंट। फिक्सेशन मीन्स कम्युनिकेशन इज इंपॉर्टेंट। हाउएवर फिक्सेशन इज नॉट अ इंडियन टर्म। अगर हम यूएस या इंग्लिश लॉ की बात करें तो वहां पे फिक्सेशन टर्म है, इंडियन लॉ में फिक्सेशन टर्म नहीं है, इंडियन ये कॉपीराइट एक्ट में। तो वहां पे उसको फिक्सेशन को बहुत अच्छे से एक्सप्लेन किया गया है। तो कम्युनिकेट करना बहुत ज्यादा जरूरी है। तो फर्स्ट कम फर्स्ट सर्व तो है ही है सर।
And sir, two more questions that I'll take. It's a very interesting. One person is asking that whether any online lecture or any online session for third party for commercial use. So is it means can we do the copyright of that?
सर सेक्शन 52 ऑफ द इंडियन कॉपीराइट की अगर हम बात करें, या एक टर्म है बहुत अच्छी, मैं एक्चुअली भूल रहा हूँ, कॉपीराइट लेफ्ट, एक टर्म है कॉपीराइट लेफ्ट।
यस,
ठीक है। तो और यहाँ हम बात करें सेक्शन 52 की, तो उसको उसमें बोला गया है गुड फेथ, या हम पब्लिक बेनिफिट के लिए अगर यूज कर रहे हैं तो ठीक है, लेकिन कमर्शियलाइजेशन कैसे कर सकते हैं? नो वन कैन एनरिच हिमसेल्फ ऑन द एक्सपेंसेस ऑफ अदर्स। तो व्हाटएवर I invest in my lecture, how the other person can commercialize it except me? So this is the basic idea of the intellectual property right.
Okay. And sir, in similar way, another person is asking whether any social media content can be copyrighted or not.
हाँ, तो अगर देखिए अभी हम बात करें तो इट्स वन ऑफ द डिबेटेबल टॉपिक लाइक सोशल मीडिया और द ओटीटी प्लेटफॉर्म्स, जिसके ऊपर अगर हम इंटरनेशनल लेवल पे भी देखें तो डिस्कशन चल रहे हैं। और अभी सिवाय अगर हम इंडिया की बात करें तो हमारे पास एक जो लॉ है जो गवर्न कर रहा है आईटी एक्ट, और अगर आईटी एक्ट भी देखें तो आईटी एक्ट भी स्पेसिफिकली कंटेंट इंडस्ट्री या ऑनलाइन पायरेसी या इसके रिगार्डिंग एक्सेप्ट पनिशमेंट या स्ट्रिंजेंट प्रोविजंस अवेलेबल नहीं है। जैसे कि हम नेटफ्लिक्स की बात करें या यूट्यूब की बात करें, however there are some principle of the takedown notices if we talk about, लेकिन अगर हम स्पेसिफिकली लॉ की बात करें तो कंटेंट को ऐसा प्रोटेक्शन नहीं है। इवन अगर हम कॉपीराइट एक्ट की बात करें तो वहां पे टीपीएम की बात की गई है, टेक्नोलॉजिकल प्रोटेक्शन मेजर्स की बात की गई है, लेकिन यूज अगर आप कर रहे हैं तो देन यू शुड बी वेरी अवेयर not to use the available resources.
Thank you, sir. Dear participants, I think you are having some doubts or a lot of queries are there, but unfortunately, all queries cannot be, answered in a short time program. So, but I would request all of you, if you have any query, we have already mentioned our email ID. So you just all together, you just send us to us so that we can also clarify through our patent office. Dr. Khosla is there. He will be assisting you. So with these few words, um, now we have come closer of this program. So now in the today's this enlightening session of the National Intellectual Property Awareness Mission, it's my pleasant duty to propose the vote of thanks. So on behalf of the Institution of Engineers India, I extend our heartfelt gratitude to Dr. Hemant Khosla for sharing his valuable knowledge, rich experience, and expert insights on intellectual property rights. Sir, your presentation has significantly enhanced our understanding of trademark, copyrights, then geographical indications, and the broader intellectual property ecosystems, specifically in India. We are deeply thankful for the time and efforts that you have already devoted to making this program both informative as well as very much attractive. And just briefly, I'm saying some few words what you have already covered during your this long lecture. You have already covered the basic understanding of copyright, then patent, then design of any products, then the trademarking of any company, of any startups, logo, writing, everything, and the economic rights also you have already covered. And most interestingly, that you have shown very nicely how the patent can be filed, or how the trademark can be filed, or design can be filed, and what are the benefits of doing all these things. And for public utility, and specifically the newcomers or young generation who are coming up with their new innovative ideas, I hope that they will be very much helpful for this, thought-provoking lectures. So our special thanks to the Department of Promotion of Industry and Industrial Trade, Ministry of Commerce and Industry, Government of India for launching and promoting the National Intellectual Property Awareness Mission, which is playing a pivotal role in fostering an innovation-oriented culture across the country. So I extend my gratitude to all the faculty members, professionals, researchers, students, participants who joined this program and enriched the discussion through their active participation and keen interest. So your enthusiasm demonstrates the growing importance of intellectual property awareness in academia, industry, and society. So I'd like to acknowledge and thank all the team members of the institution for their hard work ensured the successful conduct of today's program. And it's my privilege to enlighten you that almost 200 people who have been joined this program from all over the country, and we are really thankful to them. And lastly, I thank you all for your presence and participation. Thank you very much, and Jai Hind. Thank you, sir.
Thank you, sir.